given by Mr. Sachin Kumar. Without further ado, I would like to introduce our first speaker of the day, Ms. Deeksha Malik. So Deeksha ma'am graduated from NLIU Bhopal in 2018, and she is currently an associate working with the Employment, Labor and Benefits team at Khaitan and Company. As such, she is significantly involved in advisory work for clients on matters relating to employee benefits and entitlements, working conditions, social security, workforce restructuring, employee misconduct, including workplace harassment, employee stock options, etc. She is also the founder editor at the Indian Review of Corporate and Commercial Laws, a blog that publishes articles authored by law students in the area of corporate law and other related subject areas. Recently, she started a YouTube channel of her own to help law students and the public at large understand the nuances of employment laws. This is just a glimpse of her endless list of achievements and initiatives. We are honored to have her as a speaker for this workshop. Over to you, Deeksha ma'am.
Thank you so much for that wonderful introduction, Mansi. I'm not sure if I deserve all the praise that you've given to me, but thank you so much for reaching out to me for this. And thanks to all who have joined this session on a Saturday. I mean, Saturday combined with a study on employment laws. Not sure if that's a great idea, but I'll try my best to ensure that this session is engaging and I'm able to cover at least the basics of each of the important labor and employment laws. Because I mean, I'm sure you would agree that when we have around 100 labor laws in India, probably more than that, it's really hard to capture the essence of every legislation in a 1 hour session. But I understand and I also concur with the idea that you cannot have more than 1 hour session on employment laws. Yeah, I think with that we can start with the session. All right. So, as the topic suggests, the idea would be to cover the basics of employment and labor laws in India. Now, just a caveat here, I will try to cover the current labor law regime in this particular session. And tomorrow's session would focus on the upcoming labor codes, because I'm sure you would be keen to know what's really going to change. And contrary to what media reports have been suggesting, there isn't going to be a significant change in at least the substantive compliances. Of course, few things are definitely noteworthy. For example, digitization of processes and ease of compliance to a certain extent. Things have been consolidated, so you don't have multiple definitions of different terms like employee and wages. So to that extent, yes, it's a commendable effort, but it isn't a significant, change or paradigm shift from what exists currently. So that is the overview, and I think we can move to the next slide. All right. So labor laws, I mean, it's really hard to categorize them into different categories, but I've attempted to do that in this slide. So what I'll do in the subsequent slides is that I'll cover the labor laws under different categories. So one category basically consists of labor laws that regulate the employment and conditions of service of employees. So when I say conditions of service, I'm talking about hours of work, I'm talking about leave entitlements of employees, and even other conditions of work to which an employee would be, subjected to. So that is the first category. The second is about remuneration. So aspects relating to payment of wages, minimum wages, all these items would be covered in that category. Then the third is with respect to social security. Now, there are certain protections, there are certain and entitlements that are given to employees under labor laws, which are sacrosanct in nature. And these are basically provident fund, gratuity. So I've tried to cover those in the third category. Fourth is laws for special categories of workforce. Here, I will talk about laws that are specially designed for specific class of employees, such as women, such as transgender persons, such as persons with disabilities. So I would try to cover those here. In industrial relations, I will talk about industrial disputes and also collective bargaining related aspects that are relevant to a specified category of workforce called workmen. So I'll try to cover that in that particular category. And last is contract labor. So contract labor is a, a different category altogether because that category doesn't comprise an organization's own employees. It talks about the workers of another agency, and you are basically engaging the workers of that agency for certain, services, ancillary services in your organization. So with this, let's move to the next slide. Yeah. So the first is regulation of employment and conditions of service. Now, broadly speaking, all the organizations in India can be divided into two buckets. First is manufacturing establishments, where any kind of manufacturing process is carried on. That would be governed by a central law called Factories Act. And then there is another category of organizations which are called commercial establishments. So all the service sector organizations are covered in that category. Take, for example, Khaitan. So Khaitan is a legal services organization. It's not manufacturing anything. So it would fall in commercial establishments category. Now, this category is not governed by any central law. Central law regarding conditions of service. It's basically governed by Shops and Establishment Statute, which is enacted by each state. So let's move to the first category, which is manufacturing establishments. So, like I said, there is no state law that governs these manufacturing establishments as regards their conditions of service. It's the Factories Act. Now, the most important thing is what is manufacturing process, right? So there is a specified definition under the Factories Act. It basically talks about different activities like repairing, making, breaking articles, and cleaning, washing, different kinds of activities that you can do, even repairs for that matter. All these activities carried on in relation to an article with a view to its use, sale, transport, delivery, or disposal. Okay. Now, this italicized expression in front of your screen, basically, that is the important part. That is the operative part, because a lot of times people think that a factory, which is basically an organization carrying on manufacturing process, it would only cover those organizations which are producing products for sale or articles that are marketable. But the Factories Act doesn't look at things in that way. It also covers any factory where only raw materials are being, either altered or refined for the purpose of converting it into a finished product by some other organization, right? So even such factories are also covered within the purview of with a view to its use, sales. So it's basically under excise laws or under indirect tax laws. Basically, the definition of manufacturing process is very limited. It talks about only marketable products, but labor laws generally have wide definitions covering a lot of organizations. So that's the idea with respect to manufacturing process. Now, the workers engaged in a manufacturing process are given certain entitlements under Factories Act. Now, when I say workers, I'm talking about both workers who are working at the shop floor and also supervisors of these workers. Okay, so I may not be actually, executing something in the factory. I may just be supervising the work of another worker, but even I would be considered as a worker under Factories Act. So the definition of worker is wide enough to cover different grades of employees. Okay? So now, just giving you a broad overview of how the Factories Act looks like. The first few chapters relate to health, safety, and welfare provisions. So, every employer there's a general obligation on the part of every employer to maintain health and safety at its workplace. And this is why, and this provision actually became prominent during the COVID-19 pandemic, because at that point, people used to think that is there a general obligation on the part of the employer to ensure that there are adequate protections available, preventive measures taken at the premises. So where is that provision coming from? It's basically coming from this particular section that says that every employer has to ensure health and safety at its workplace and has to do all reasonable efforts towards that goal. So this is the general obligation, and then in furtherance of that, there are specific obligations, such as providing medical. There's a requirement regarding medical examination of workers. You have to conduct an annual examination, medical examination of your employees. Then there are provisions regarding providing first aid facility to your workers. So that is there. Then even under welfare provisions, you have canteen facility that you need to provide to your workers. So it actually covers a lot of provision, but I'm just trying to cover everything uh, in a very concise manner. So yes, there are certain chapters which talk about health, safety, and welfare provisions. Also, when it comes to safety, if you read Factories Act with the state-specific rules that are framed under this act, basically, there are requirements regarding notifying to the authority whenever there is an accident occurring at the premises of the factory. So that obligation also exists. Then, if there is any occupational disease happening, again, you need to notify to the competent authorities under each state. So there are all those requirements. And when we talk about hazardous operations, there are certain factories which carry on hazardous operations, dangerous operations, and these are explained under the Act. What all activities are, considered as part of hazardous activities. So for all these factories, there are certain additional obligations. For instance, you need to have a safety committee, and that committee will comprise of both employers' representatives and workers' representatives, which will examine what kind of safety measures exist in the organization, right? So all these provisions uh, basically fall under the expression health, safety, and welfare provisions. Now, coming on to one of the most important provisions, which relate to working hours. So, the workers are, you cannot engage them 24/7, unlike in law firms where you know how things are. But in factories, you have specified daily and weekly working hours. So I cannot engage a worker for more than 9 hours in a day and 48 hours in a week. If I intend to engage them for more number of hours, then I have to ensure that I pay overtime to them. And what is overtime? It is basically twice the ordinary rate of wages that I would pay to a worker. So I have to pay that overtime for the extra number of hours for which I am engaging a worker. Then there are provisions regarding intervals of rest. So I need to ensure that after every 5 hours, I'm giving half an hour rest interval. Then you have spread over. Spread over is basically the total number of hours for which a worker can be present at the premises. So it's not just hours of work, it's hours of work plus rest intervals. So combine how many hours I can engage or allow a worker to be present at the premises, that is called spread over. So spread over limit is 10.5 hours. So that is also specifically mentioned under Factories Act. And then you have other things like compensatory off. So if I'm engaging a worker on a weekly holiday, then I have to ensure that I'm allowing that person to take a compensatory off within the next 2 months. So that's with the compensatory off. Then there are certain regressive provisions also that exist. You have a provision that says that you cannot engage women in night shifts. So when I say night shift, I'm basically talking about hours after 7 p.m. and before 6 a.m. And this provision, by the way, has been held to be unconstitutional by the Madras High Court in Vasanta versus Union of India. And interesting fact is, that people say that if only one High Court has declared a statute as unconstitutional, it it may mean that for other states at least the provision is constitutional. But actually, it's not so. There are Supreme Court judgments which have said that even if one High Court declares a statute as unconstitutional, it will be unconstitutional throughout the country. So we have a Kusum Ingots case of Supreme Court that basically says so. And there are, if you read Gautam Bhatia's, blogs and other constitutional experts' blogs, they have also, critiqued on this particular aspect. So I'm not going into that, but just wanted to give you a perspective that even though Madras High Court has declared this provision as unconstitutional, it still exists, and you cannot really engage women in night shifts. So that is with respect to working hours. Now moving on to annual leave with wages. So basically, in any given year, I have to give 18 days approximately of annual leave with wages. And in case I do not avail those leaves, I end up taking only 9 leaves. So those keep getting accumulated. Of course, there are accumulation limits also, like I cannot accumulate beyond 30 leaves in the course of my employment. And when my services are terminated, at that point, whatever unavailed leaves exist in my leave balance, those can be encashed by me. I will get money in lieu of those leaves because I didn't take them. So I will get a kind of a payment for not doing so. So that is annual leave with wages. Important thing is what happens when these provisions are not complied with. So the liability is imposed on the occupier and the manager of the factory. Now, who is an occupier? When we talk about companies, so first of all, there's a general definition of occupier, which basically says that any person who has ultimate control over the affairs of the factory, that would be considered as an occupier. But then there is a deeming provision which says that in case of a company, any of the directors can be considered as an occupier. So let's say I have 5 directors, but I have notified to the competent authority that director A would be considered as occupier, then other directors will not be considered as occupier. Then only the director who has been mentioned as such as occupier, authorities will come only after that director. So this has been held by the Supreme Court in one of the cases, JK Industries case, where the Supreme Court has held that you cannot go after other directors. And there are other interesting, aspects around the concept of occupier. Like, for example, very recently, a client asked us if an independent director can be considered as an occupier. Because if you see the definition of occupier, it says any of the directors. So you might as well cover independent directors as well. But we have always advised that the essence of an independent director is that you are not involved in the functioning of the organization. So if you read Factories Act with Companies Act and the code of conduct which exists for independent directors, they cannot be engaged or they cannot be designated as an occupier. So a lot of nuances, very interesting concepts that we keep encountering in practice. But yeah, this is about Factories Act. Moving on to the next slide. And this is about commercial establishments. Yeah. So very similar provisions like Factories Act, you have very similar provisions under each of the state-specific shops and establishment statute. Now, generally speaking, a lot of these states exempt managerial employees from the purview of shops and establishment statute, right? So what do you mean by managerial employee? Managerial employee is basically a person who has some kind of a decision-making power in the organization, who has some discretion over, strategic decisions of the company, and who is not really, involved in the implementation work. It's not actually, that person is not actually performing the job, but rather is engaged in a supervisory position and involved in, policy making, functions in the organization. So basically, the senior level, employees are generally considered as managerial employees. And here the remuneration part is not important. So for example, if a shop floor worker is getting 1 lakh rupees, you cannot say that that person is managerial only because the remuneration is high. So remuneration is not an important criterion here. What is important here is what is the predominant nature of the activities, or the responsibilities of the person. Okay, so these kind of people, the managerial employees, are normally exempt from Shops and Establishment Statute. So this is one important deviation from Factories Act. So in a commercial organization, what happens with respect to managerial employees? How are they governed? Very simply, they are governed by their employment contract. So, um, yeah, I mean, with respect to managerial employees, employers have a lot of discretion, and they have also arbitrarily used that discretion even during the COVID-19 pandemic. They arbitrarily altered the conditions of service of these people. Of course, that is not legal because you have a contract in place, and if you are modifying that, of course, you require the consent of the employee. So that is there. And remember, whether we are talking about managerial employees or non-managerial employees, there are certain protections which are available. For example, notice pay. So in India, we do not have a employment at will concept which exists in USA. If I'm in US, I can tell my employee, don't come from tomorrow, and that's it. But in India, I cannot do that. I have to give a reasonable notice to my employee. So for non-managerial workforce, you have statutory protection. Statutes clearly say that you have to give notice. Shops and Establishment Statute also have a provision which says that you have to give at least 1 month of notice when you are dismissing the services of a person. For managerial employees, even though there is no statutory protection, but there are case laws that basically say that even if the contract, their employment contract, doesn't mention a notice period, they are still entitled to notice period. So, not venturing into the case law at the moment and focusing on what's there under SNE Act. Again, there are provisions regarding daily and weekly working hours. So every state has come up with its own limits. But broadly speaking, daily working limit is 9 hours, and weekly, it's basically 48 hours. Some of the Shops and Establishment Statute also place an overtime limit. So if I'm engaging, an employee on overtime basis, so aisa nahi hai that I can, keep on engaging that person for howsoever, how many number of hours I want to engage that person. There are caps, quarterly caps sometimes that, in a particular quarter, I cannot engage an employee for more than 175 hours. So that covers overtime hours as well. So those nuances are also there, but it actually, depends. It varies from state to state. So I will not go into that. Weekly off is one provision that you will find in each of the Shops and Establishment Statute. You have to give weekly off to your workers, and even if you are operating 24/7, you have to ensure that at least 1 day is given to them as a weekly off. So in some statutes, it is said that there's an absolute embargo. You cannot engage someone, during a weekly off. In some Shops and Establishment Statute, it's said that okay, you can engage a person on a weekly off, but then you have to give a compensatory off, or you need to pay an extra amount to that person for engaging, in any of the weekly offs. So there are some variations around weekly off concept as well, but that's the general overview. Interestingly, there are some statutes which also prescribe a format for appointment letter. So I've seen a lot of people saying that in India, there is no requirement under law to give a written appointment letter. That is incorrect. The Shops and Establishment Statute of states such as Delhi, um, very specifically mention that you have to issue a written appointment letter, and it will consist of certain basic things like, the wages that you are paying, the benefits that you're giving to the person, the nature of work designation, like just the basic items that have to be recorded in writing. There's a prescribed format under the rules which are framed under Shops and Establishment Act. So that is there. But broadly speaking, most of the statutes do not have the written appointment letter provision. There are very few states that have that provision. But this part is going to change under the labor codes, because there is a clear provision under one of the labor codes that says that you need to issue a written appointment letter to every employee, whether managerial, non-managerial, doesn't matter. You have to issue a written appointment letter to everyone in a prescribed format. So coming to the last part, which is leaves. So now, unlike the Factories Act, where we have annual leave, here we have a division. There are certain leaves called earned leaves, which are essentially similar to annual leave that I talked about. And you have the option of encashing them also at the time of termination of employment. So earned leave is akin to annual leave under Factories Act. But in addition to that, you also have certain leaves called casual leaves. Casual, as the name suggests, you can really avail that leave at any point. Normally the number of casual leaves under any SNE Act would be 7 to 10. So I have that bucket of leaves as well. Then sick leave, in certain SNE Acts, it's written that I cannot avail sick leave for any reason. I need to provide a medical proof in order to avail that leave. So these are basically the three kinds of leaves that you will find. Few SNE Acts also do not necessarily have all the three kinds of leaves, but this is generally the overview. So moving on to the next slide. Yeah, so remuneration, I'll just spend 5 minutes on this particular category. So moving to the next slide. Now, minimum wages, I'm sure every one of you would be aware of this statute. It basically says that for any worker, and here, I think the definition, the term uses employee, not worker. And it basically says that any kind of work employee, whether skilled, non-skilled, unskilled, everyone, or even semi-skilled, all these kinds of employees will be entitled to minimum wage protection. So every state comes up with a minimum wage rate notification. It mentions a particular rate. So if it says, in any particular month, 10,000 rupees is going to be the minimum rate. So the employer has to ensure that the wages of the employee is at least 10,000. Okay. So in the notifications, in any state notification that you read, you will find that there is a division made. For unskilled, the rates are normally low. For semi-skilled, they are higher. And then skilled employees, it's even higher. But not every time we get to see a definition given to these three categories. So some states very clearly mention what would be a who would be a skilled employee, who would be unskilled, semi-skilled. But a lot of times we do not see that division clearly made. So then we have to, go back to case laws and try to understand how courts interpret a skilled employee or an unskilled employee. So yeah, I think that is one part that is not clearly addressed under Minimum Wages Act. There are no specified definitions of these three categories. Yeah, that's basically minimum wages. Moving on to the next slide. Now, payment of wages. This act primarily applies to factories, mines, plantations. So very few states have extended its application to commercial establishments also. Remember that earlier categorization that I did, factories and commercial establishment. So this statute primarily applies to factories, not commercial establishments. Now, here there are certain entitlements or protections given to specified categories of employees, basically employees who are earning wages up to INR 24,000 per month. Now, doesn't matter if that person is managerial, non-managerial, duties are not important here. What is important is the remuneration. So even if I'm a managerial employee, but getting wages up to 24,000 rupees, I will be entitled to protection under Payment of Wages Act. Now, what is the protection like? Basically, it's provided that you need to, there's a timeline given for payment of wages. So by the 7th of next month or by the 10th of next month, there are two timelines given depending on how many, basically depending on the number of employees that you have. So if I have less than 1,000 employees, then I have to ensure that I'm paying wages to them by the 7th of the next month. And if there are 1,000 or more employees in my organization, then I have to ensure that I'm paying wages to them by the 10th of the next month. Likewise, when it comes to termination of employment, it's mentioned that I have to pay whatever dues exist with respect to the employee within 2 working days from termination of employment. So that kind of gives some protection to the person when he or she is leaving the organization, that yes, by a certain timeline, he would get the wages he deserves or he's entitled to. Then there's another protection in the form of deductions from wages. So I may be deducting, different kinds of, payments from wages. For example, if the employee has taken loan from me, so whatever the amount is, the amount of loan, I may want to deduct it from his or her wages, right? But there are certain limits to that. So it's mentioned that deductions can be of different kinds. If an employee has conducted misconduct, I can also deduct some fine from his or her wages. But whatever deductions there are, they cannot exceed 50% of the wages. So all kinds of deductions taken together cannot exceed 50%. So at least I will get 50% of wages at any cost. So that kind of protection is there under Payment of Wages Act. And yeah, let's move to the next slide. Oh yes, we have payment of bonus as well. Now this act applies to uh, any establishment which has 20 or more employees. But the protection, the entitlements are given only to employees uh, who are earning wages not more than 21,000 per month. So basically what's provided here is that you have to give minimum wages, minimum bonus to every eligible worker, every eligible employee, and that minimum bonus would be equal to 8.33% of the salary. Okay, so utna amount I have to pay as minimum bonus. Doesn't matter if I'm earning profits or not. Even if I'm incurring losses, I still have to pay minimum bonus. In case of maximum bonus, it's payable only when I'm earning profits. And if I'm basically the surplus that is available with me, if it exceeds the minimum bonus that I've paid, then I have to, out of that, additional surplus, I have to also pay maximum bonus up to 20% of the salary. So maximum bonus is not payable every time. If you are earning profits, only then you will pay it out. Otherwise, it's minimum bonus that is definitely given to every eligible employee. So that is that with the remuneration aspects. Moving to the next slide. Yes. So social security is one of the most important parts under employment and labor laws. So I'll quickly move to the first one, which is EPF Act. Now, this statute applies to every establishment which has 20 or more employees. Again, doesn't matter if that employee is eligible for the benefits or not. But the moment I have 20 or more employees, this act becomes applicable to me. But the benefits are normally, available only to a person who is earning basic wages not more than 15,000 per month. But there's an important catch here. If I'm earning more than 15,000 also, I can opt for the benefits under EPF Act. So that facility is also available, and many employees do that. In even if that person would be, one of the key managerial personnel, they can also, opt for the benefits under the EPF Act. But it's purely voluntary. Uh, but primarily, this applies to that 15,000 bracket of employees. So it simply says, this act simply says that every month I have to deduct a certain percentage from the basic salary of the employees, and basically that percentage is 12%. So 12% of basic wages is what I have to deduct from the employee's basic salary, and basically employees' wages, and then deposit it to the employee's provident fund. So every month I'll keep on doing that. And after a certain point, after retirement, that person can claim the benefits under EPF Act. So the contribution here is made both by the employee and the employer. Okay. So that 12%, which is deducted from wages, that is one. But a matching contribution has to be made by the employer from its own pocket. So there is some, interesting nuance around what is basic wages, because you compute 12% on the basic wages. So here we had a very important judgment of the Supreme Court of India in 2019, which is RPFC versus Vivekanand Vidya Mandir judgment. And in that judgment, basically, the Supreme Court said that basic wages is not what you are showing in the salary structure as basic wages. Any promised payment that you are paying to employees across the board, those would be considered as basic wages. So, for example, in my salary structure, I have mentioned that, the employer has mentioned that I will get 10,000 basic salary, 5,000 medical allowance, 10,000 education allowance, and hundreds of other allowances. But if those allowances are paid to every person in the relevant grade, in the relevant category, then those allowances would also be considered as part of basic wages. So I cannot, tomorrow create this facade that, your basic wages is only 5,000. So I'll compute EPF contribution at those 5,000. No. If other allowances are also promised to me, and they're promised to every person who is employed in my category, whatever grade I am in, then those allowances should also be taken into account, and you will total them up and then compute 12% on that total. Okay? So that's basically the judgment of Supreme Court of India. And moving on to the next one. This statute basically gives certain health, life cover, and medical benefits to certain categories of employees. The act becomes applicable the moment you have 10 or more persons. Again, doesn't matter whether these persons are eligible persons or not, eligible for the benefits under the act. The moment I have 10 or more persons, I have to register myself as an organization under the ESI Act. Okay. But the benefits are available only to persons who are earning wages up to 20,000 rupees. Again, just like EPF Act, there are certain contributions that the employer has to make. In the slide, I have mentioned the rate of contribution that the employee has to make, which is lower. It's just 0.75% of the wages. And the employer has to basically pay from its own pocket 3.25% of the wages that it is paying to the employee. So this is it with respect to ESI Act. Moving quickly to the next one, gratuity. Gratuity is one statute which I can call universal because it applies to every kind of employee. Doesn't matter what wages they are earning, doesn't matter whether they are managerial, non-managerial, every person is covered under Gratuity Act, provided, of course, for the benefits, yes, there are certain criterion that they have to meet, but at least from a coverage perspective, everyone is covered. So again, this statute applies the moment there are 10 or more persons. Okay. Now, an employee, okay, first of all, talking about what is gratuity. Gratuity is basically a terminal benefit that I get. It's basically a reward that I get at the time of cessation of my employment. It's not given during my employment. It's paid when my services are, there is a cessation of employment. At that point, gratuity is given to me in recognition of the period of time that I've spent in the organization. So, of course, because it's a service tenure-based reward, so it is paid only to people who have completed at least 4 years and 240 days in the organization. Okay. So if I have completed that period of time in the organization and then my services are terminated, then I will be given gratuity. Then there is a formula that you can see on your slide that is basically paid for every completed year of service. So that is the competition that is there. So yeah, this is a terminal benefit that an employee gets at the time of cessation of employment. Moving to the next slide. Okay, this is my favorite part because it talks about entitlements for women. And moving quickly to the first one, which is maternity benefit. I'm sure you would have heard about it somewhere or the other. It's basically a benefit that a woman gets, uh, you know, with respect to maternity. And again, this statute becomes applicable the moment there are 10 or more persons. But women are entitled to maternity benefit if they have completed 80 days in the organization. So that is the minimum time period that they have to complete, and then they are given maternity benefit. Now, maternity benefit is of different categories. One is in relation to pregnancy. So I'm sure you would know that 26 weeks is the amount of paid leave that I will get on account of maternity from my employer. And I mean, of course, there are certain further requirements that, prior to delivery, only 8, weeks can be given. All those things are there, but broadly speaking, 26 weeks is the entitlement that I will get. Likewise, there are also entitlements for uh, an adopting mother, a commissioning mother. So all those things are also there. And then aside from these maternity benefits, there is also a payment which is called medical bonus that I will get for prenatal and postnatal care. So the employer has to give that amount, which is basically between 2,500 and 3,500 rupees for prenatal care or postnatal care. So these are certain entitlements that exist. And whenever a woman is employed, uh, she has to be notified about all the benefits she will get. And that notification can be done either by way of her appointment letter or through the company policy, which can be notified to her. But you have to notify all the benefits that you have to pay or give under the Act. There are several other protections also. For example, when a woman has proceeded on maternity leave, I cannot dismiss her services. I cannot alter the conditions of service. When I say conditions of service, I'm talking about wages. Sometimes courts have extended that to even promotion. That, if I had been eligible for promotion, so you cannot take that away from me. But I will not go into that because that's quite debated, because promotion is never promised. But basically, anything that has been promised to me as part of my terms of employment, I cannot alter those when a woman has proceeded on maternity leave. So these are certain benefits that a woman gets. And remember, the definition of woman here includes not only a woman who is employed by the organization, but even a woman who is a contract worker. So I had mentioned in the initial slide that there are certain contract laborers which are engaged by the organization. Now this could be basically someone who is actually employed by another agency, but I'm availing her services for housekeeping, for example, right? So for all these ancillary activities, I do not normally engage my own employees because there are a lot of employee related costs that I will have to incur. So what I do is I do not engage my own employees for these ancillary activities like housekeeping, loading, unloading, all these activities. What I do is I reach out to an agency and say that, I just need around 10, 15 people for housekeeping activities. Can you just send your workers? And then that contractor or agency will send its own employees to this particular organization. So even such contract workers, if there's any woman who is a contract worker, she also needs to be paid benefits under this Act. So if her own employer, who is the contractor, is not giving her maternity benefit, she can approach the principal employer, the one who is engaging her services, and ask for maternity benefit from that principal employer. So this is it with respect to maternity benefit. Moving to the next slide. Oh, yes, POSH. This is one area where our practice becomes really interesting. we come across so many cases where, there are genuine cases of sexual harassment. There are also some really, I would say, problematic cases where we know that the complaint is false. So how to really help our clients, in that situation, because the woman sometimes threatens that she will resort to social media posts if, you know, the accused is not punished. So we come across all those, problems, but broadly speaking, uh, the prevention of sexual harassment, it's basically called Sexual Harassment of Women at Workplace, Prevention, Prohibition, and Redressal Act, 2013. This statute doesn't have any threshold. It applies to every, organization. I may be having only one employee also, but this act will become applicable to me. Uh, so that is interesting, a deviation from other labor statutes that we just discussed. Um, so one important aspect here, I haven't covered it in the slide, but it's very important that the woman here, the aggrieved woman, can be employed or need not be employed with the organization. Okay, but she can get her grievances redressed by the particular organization. If sexual harassment has committed at a particular organization's workplace, I can approach the employer and seek, or rather the head of the organization, and seek redressal. Even if I'm not employed, with that organization, I may be just, a client, and approaching that particular office for some work. But if sexual harassment is committed at that workplace, then I will be entitled to redressal. But the respondent here, uh, who is basically the accused, can be a man or a woman. We have seen, in fact, cases where the person committing sexual harassment was, in fact, a woman. Uh, so, so respondent would cover both man and woman. That person needs to be the employee. And why so? Because if I'm seeking redressal from that organization, what kind of redressal it would be? It could be termination of the services of that particular accused, right? So if that organization doesn't have an employer-employee relationship with the accused, what punishment can it give to that person, right? So it's important that the accused is actually employed in that organization. Only then can punishment be given to that person. So that distinction is important between respondent and accused. My bad, respondent and the aggrieved woman. Now, when it comes to workplace, this is also very broadly defined. It basically covers not just the actual premises of the organization, but also any journey that the woman may undertake in the course of her employment. So I may be, going for off-site, activities. I may also be going for those annual retreats that are, organized by the organization. So uh, that that entire course of my journey, and anything happening to me during that particular journey, that would also be covered under the act, because workplace is that widely defined. Now, an interesting question that we came across, especially during COVID times, was whether a woman's home could be considered as a workplace. So, for example, my employer has told me that from today onwards you can work from home, and I am, having a Microsoft Teams meeting with another colleague of mine, and something untoward happens. You know, uh, so, there are some sexual remarks that are passed in the course of that conversation. So the question that comes is whether, so I'm not at my office, but the question will be whether my own home can be considered as a workplace, because this is where the act is happening, right? So uh, now here the jurisprudence is very limited. People say that, oh, workplace is widely defined. It will cover, because it says that it covers the journey also. So it will cover, an employee's, a woman's home also. But that interpretation is not right, okay? Because journey being undertaken is different. I'm not undertaking a journey when I'm at home, my own home, right? So strictly, applying the literal interpretation rule, one can argue that workplace doesn't include an employee's own home. And if you see certain, case law on this point, what courts have emphasized is that you read the definition of workplace along with the definition of employer. Okay, so employer definition under POSH Act says that employer is someone who has control, supervision over the workplace. So when it comes to my home, can I say that the employer has control or supervision? That person is not owning this premises. That person has no control over this particular property. So by that logic, courts have said that basically any other premises which you are trying to cover under workplace has to be under the control of the employer. So if you go by the case law, one can argue that an employee's home is not part of workplace. But what we advise our clients is that no, you take cognizance of complaints from such women also who are experiencing sexual harassment at their own homes, uh, because at the end of the day, you need to adopt purposive interpretation, right? I mean, just think about it. If an organization has declared work from home for all its employees, so no employee is actually working at the premises. So can you see that POSH Act is not applicable? It would be a very bizarre conclusion, right? So we always say adopt a purposive interpretation and cover these women also. Now, coming to an important okay, so someone has asked what's the case name. It's, I think, Saurabh Kumar Malik case. It's Saurabh Kumar Malik versus Comptroller and Auditor General. So in that case, the ratio has basically emphasized on the control element between the employer and the workplace. Now, coming on to one of the most important obligations of the employer, if there are 10 or more employees in the organization, then an internal committee has to be formed. In certain states, you have to also register that internal committee. I'm not going to that. But internal committee will basically has to be constituted, and there is a proper composition that is provided under the law. So, Mansi, if you can just move to the next slide. Yeah. So this is how the internal committee will look like. The presiding officer has to be a woman, a senior woman at the workplace. Now, it's possible that my office doesn't have a senior woman employee. So, in that case, I can ask one of the other group entities of my organization that, okay, how about, just appointing your senior woman employee as the presiding officer of my internal committee? You can do that. And what if even the group entities do not have any other senior employees as women? Then you can also appoint a presiding officer from any other organization. But we usually do not advise that because at the end of the day, it's an internal committee. The process has to be internal. So if you are getting external people who have no relation whatsoever with the organization, then it's not truly internal in nature. So there are certain nuances, but yes, this is how the provision talks about the requirement of presiding officer. Then there has to be at least two employees, your own employees, who are committed to the cause of women. And I mean, committed in the sense that they could be part of NGOs or whatever. Uh, but yeah, they should be familiar with the issues relating to women. And last and the most important is that you need to have an external member. This person can be from an NGO or can be a person who is familiar with labor laws. So even we sit as external members sometimes in the internal committees of different organizations. So because we are experienced in labor laws, so external member has to be truly external. And in fact, there are case laws to the effect that if you do not have an external member and you have basically conducted an inquiry into a complaint, then that inquiry can be quashed. So, what will be the remedy here? Basically, court will normally say that we are directing the internal committee to first be. We are basically directing the employer to reconstitute the committee and again conduct the inquiry in accordance with the law. So, this is normally the remedy that is given. But what if an organization doesn't have an internal committee at all? It's not about improper constitution. It's no constitution at all. In those cases, a fine can be imposed on the company. This fine would be a maximum of 50,000 rupees. But if I commit that offense again after being convicted once, then even the license or the registration that I have been given to operate that premises under any under company law or any other, for example, if I'm an insurance company and I'm a registered insurer under IRDAI. So if I commit this offense again of not properly of not constituting an internal committee, then that license, that approval that has been given to me can be revoked. So it's a drastic penalty that only one labor law statute provides for, and that is POSH Act. So this is it with respect to POSH Act. So I think I'm really, short of time right now. So I'll just quickly go through other statutes as well. Moving to the next slide. Yes, so rights of persons with disabilities. Now, this statute is really broad, okay? It talks about even educational entitlements of persons with disabilities. There's only a small portion of this law that talks about employment related aspects. And first of all, what is disability? Disability is very broadly defined. It says that uh, any kind of a condition that really hampers my effective discharge of my duties, in the society. So it basically hampers that normal functioning. So that is disability. Uh, so of course, there are a lot of case laws around this. We recently, came across a Supreme Court judgment where the court has held that heart ailment is not disability. So, there are various case laws around this, quite interesting ones. But coming to the obligations of the employer, basically every employer has to formulate an equal opportunity policy where it will basically say that I do not discriminate against, any person on the ground of disability, and I need to register that policy with the state commissioner for persons with disabilities. I also need to maintain records in relation to persons with disabilities. And as part of this, I also need to constitute an officer who will look into the complaints of persons with disabilities. So I have to redress those complaints as well. So this is largely Rights of Persons with Disabilities Act. Moving to the next slide. Industrial relations. I wish I had covered this earlier because it's one of the most important statutes. But the statute that I'm talking about is Industrial Disputes Act. If you could just, yeah. So Industrial Disputes Act applies to only workmen category. Okay. So when I say workman category, I think I've already discussed who is a managerial person, right? So basically, any person who is not a managerial person or is not a supervisory employee earning wages more than 10,000, then that person would be workman. So workman is that residual provision, basically residual category of workers who are either not managerial or not supervisory employees. Those would be workmen. So these workmen have some really interesting entitlements under Industrial Disputes Act. One is that if I am altering the conditions of service of a workman, then I will have to give advance notice of 21 days in most of the states and 42 days in 2-3 states like Telangana and West Bengal. So I have to give that advance notice. So even if I obtain consent of the employee, that will not be enough, for altering those conditions of service. I have to actually give advance notice. And the idea of advance notice is to basically ensure a consultative process during that notice period. When the employee can voice, the workman can voice its concerns that, look, I'm not happy with this condition of service that you're trying to alter. So that is a consultative exercise that the statute necessarily imposes on the employer. Okay, so what are these conditions of service? Those are also listed in a schedule. If you are altering any of those conditions of service, then you have to give advance notice, and that includes wages, working hours, any change, adverse change. Obviously, if it's a favorable change, then obviously you don't have to give advance notice. But if it's an adverse change that you are doing, then you will have to give advance notice. Then layoff. Guys, just remember, layoff is not termination of employment. I came across this term so many times during COVID-19 pandemic, where news articles were saying that companies are laying off their employees. What they meant was that they're terminating the services, but they use the term layoff. Layoff is not termination. It is only a period of time when I'm not able to give work to my workmen. Okay. So it's basically a break, some sort of a, actually break is also not the right word. It's basically a time period when I'm not working. So, but I continue to be employed with the organization. Okay. So this is one important thing that you need to keep in mind. There is no break in service that happens uh, during this layoff period. And what is layoff? Layoff is basically a time when I'm not able to engage an employee uh, for reasons beyond my control. So reasons beyond my control would be a pandemic, where a government mandated lockdown has happened. Now, I cannot do anything about it. I have to follow the protocol and not engage my workers. So, this is something that you need to keep in mind. Layoff doesn't talk about mere financial hardships. That, today I don't have money, so bye. I don't need your services or whatever. So, this is not what layoff talks about. Okay. So, this layoff provision, remember, only relates to factories, mines, plantations, which have 50 or more workmen. And what these organizations have to do is, when they are laying off someone, they, for the first 45 days of layoff, they will have to pay 50% of the basic wages of of the employee, during that 45-day period. And after 45-day period, if the layoff situation continues, then I can agree with the workmen that, look, this situation is continuing and I cannot do anything about it. I will not be able to pay you for the remaining layoff period. Okay, so only for the first 45 days I have to pay reduced wages to the workmen. Now, what about commercial establishments? They are not covered under these provisions, layoff provisions. So in that case, okay, someone has asked me, please explain layoff point again. Mansi, is it possible for me to take that up?
Yes, ma'am, you may go ahead.
Okay, great. So layoff, as I said, talks about a situation where I'm not able to give work to my employees, even though they are employed, but I just cannot give them work for reasons beyond my control. Now, some examples of layoff are already given under Industrial Disputes Act. What are these examples? Shortage of raw materials, or a sudden breakdown of machinery. Machinery has broken down. How can I engage you, right? So that is another situation. Natural calamity has been mentioned expressly as a layoff event. And then there is one residual clause, any other connected reason. So anything that meets that threshold, high threshold, will also be considered as a layoff event. So like I said, a pandemic. Now it's again a situation beyond my control. Lockdown has happened. I did not declare the lockdown by myself. So it can also be considered as a layoff event. Okay. And in that situation, if I'm a factory, having 50 or more workmen, then I have to pay reduced wages during that layoff period. If I'm a commercial establishment, then what? I mean, is it that I don't have to pay anything? No, that's not exactly how things work. There is a Supreme Court judgment, okay, and it's basically Workmen of Firestone Tire and Company. In that particular judgment, the Supreme Court held that for commercial establishments, because there is no statutory provision governing layoff, there can be an agreement between the employer and the employee, which will expressly set out what would be the conditions of service during that layoff period. So I can declare a layoff. I have that flexibility as a commercial establishment, but there has to be a clear agreement which will talk about what kind of payment I will make, what would be the percentage of salary that I will be giving to you during that period. So there has to be an agreement. Without an agreement, I cannot, stop paying salaries to you. So that is the idea with respect to commercial establishments. Then the last bit, important bit, is with respect to retrenchment. Now, if a worker is being retrenched, and when I say retrenched, I'm talking about termination of employment. I'm not talking about resignation. Okay. So if a worker's services are terminated by the employer, then in that case, a workman will be entitled to retrenchment compensation. Okay. It's basically a compensation that I'm getting because of loss of job. Okay. And that compensation has to be given to me. Apart from that, I also will be entitled to 1 month notice or payment in lieu of notice. Okay? So if I want to retrench a particular workman today, I will have to give 1 month notice to at least 1 month notice to that workman. Or if the situation is such that I really cannot continue with that person any longer, then I will have to pay wages in lieu of that 1 month notice period. Okay. Then a third obligation. So one is retrenchment compensation, one is advance notice. The third requirement is intimation to authorities. So I have to intimate to the authorities that look, for so and so reasons, I cannot continue with this person, and hence I am retrenching that person. So I have to notify to the authorities. Now, here there's an interesting catch. If I'm talking about factories, mines, plantations, which have 100 or more workmen, then the requirement of intimation to authorities changes to permission requirement. Okay. So if I have 100 or more workmen in my organization, then even if I'm retrenching only one workman, I will still have to go with the permission requirement. I will have to seek permission from the authorities that, look, I'm removing this one person. So please grant me permission for that. So it's a very onerous provision because we're not talking about mass retrenchment here. Even for a single workman, if I'm terminating their services, I have to seek permission if I'm a factory having 100 or more workmen. So that is a very stringent requirement. And yeah, that's about it. Just one important thing that I want to mention. This is with respect to collective bargaining. Now, a lot of people have asked me whether there is any inherent right in workmen to collectively bargain with the employer. So my general answer would be no. Even if there is a statute called Trade Unions Act, okay, that Trade Unions Act only talks about registration of trade union. It doesn't talk about entitlements relating to collective bargaining. Okay, so there is no central law that grants a trade union or a section of workmen the right to collectively bargain. Okay, so that is important. There are few states which have enacted, you know, laws where trade union, can be granted the status of a recognized trade union. So when it's recognized, it gets the power to collectively bargain. And if the employer refuses to collectively bargain regarding different conditions of service, like wages and all, if the employer refuses to collectively bargain with this recognized trade union, then it can be penalized under those laws. So that is a very important entitlement that some states give. By some states, I'm mainly talking about Telangana and Maharashtra, which have those laws. Now, how am I talking about state laws here? Just remember that all these labor law statutes, this subject of labor, conditions of work, and entitlements of workers, this forms part of the concurrent list of the Constitution. Okay, so both the central and the state laws can come up with their own statutes. So that is why states have the power to come up with these additional laws. So if I have 10 trade unions, then and there's one trade union which has the maximum number of representation, then that will be granted the status of recognized trade union under these state laws, and then they can collectively bargain with me, and I have no option to refuse. Okay, so this is it with respect to collective bargaining. And can we move to the next slide? Okay, the last bit, contract labor. Mansi, let's quickly move to the next slide. Okay, so contract labor, please understand the basics here. There are so many people who are confused about this concept. Contract labor doesn't cover your own employees. Like I said, these people are actually the employees of a contractor, and I'm basically availing those, the services of those workers for certain activities in my organization where I don't want to incur employee related costs. So I don't want to, employ people and incur all those social security and all those obligations. So what I do is I would just reach out to a contractor and basically say that, look, just send 20 25 people, and for so and so activities. Okay, so again, contract. So one thing that you need to remember is that there are organizations which have these sham arrangements where what they do is that they control these contract workers for all purposes, but only on paper they are showing that these are contract labor, these are not my employees, but for all purposes they have control and supervision over these contract labor. And like I said, when it comes to an employee, how can you say that someone is an employee of the organization? You show that this person, whatever work he's doing, he's subject to the direction and control of the organization. So in case of contract labor, there should be only one thing, which is direction. I can direct you to do, okay, this is what I am expecting you to do. Okay, these are broadly the parameters and whatever, but I'm not controlling you. That control element will be with the contractor, not me as a principal employer. Okay, so this is the important distinction between an employee and a contract labor. Also, you would be asking what's the status about gig workers, who are working, like for example, Ola, Uber drivers. So India hasn't really opined, taken a decision on that yet. You have some USA states, which like California, which have opined that gig workers can be the employees of the entity that is engaging their services. Like Uber can actually Uber drivers can actually be the employees of Uber. Likewise, you have UK also recently opining on that front, but India still hasn't addressed that aspect properly. The Supreme Court hasn't examined whether these drivers are actually the employees of the cab aggregator. So the contention that you will see these organizations taking is that we only direct these people what needs to be done. How it has to be done is basically totally it rests with them. They have the autonomy, they can work whenever, they can switch off their app whenever they want to, so we don't have any control. And when there is any misconduct happening, we do not punish these people, because again, regulating someone's conduct is again a feature of employment. So what these people contend, these organizations, that look, we do not punish these people, we do not reduce their salary or terminate their services on the ground of misconduct. So really, we can terminate the contract with them, but we do not punish them in other ways, like reducing their increments or whatever. So this is important. Okay, in case of contract labor, there only needs to be direction and not control. Again, selection of contract workers should rest with the contractor, basically the hiring part. I cannot hire someone directly as contract labor. That part should remain with the contractor. Contractor will decide which workers have to be sent to the principal employer for work. Okay. Again, like I said, conditions of service, everything should be regulated by the contractor, not me as a principal employer. Again, I cannot take insurance policies on behalf of contract workers because I'm not their immediate employer, right? I don't have any privity of contract with these contract workers. So if any insurance needs to be taken, that should ideally be taken by the contractor and not me. So moving to the next slide. Okay, one of the questions that someone has asked is what's the difference between gig workers and platform workers? To be honest, the distinction is hardly there. And I will address this part tomorrow when we will talk about labor codes, because today we are talking about the current labor law regime. And in the current labor law regime, there is no concept of gig worker, platform worker. These terms have not been used under any of the existing laws. Okay, so I will address this part tomorrow. But just to broadly answer your query, there is no such distinction between the two. Now, compliances, yes. So it's not that the principal employer has no obligations with respect to contract workers. There are some protections which are available with the contract worker. For example, if the contractor, which is their direct employer, fails to pay wages to them, contract workers have the right to approach the principal employer and ask for payment of wages. So ऐसा नहीं है that principal employer has to pay monthly wages to them. No, it's only when the contractor has failed to pay that I will have to pay wages to the contract workers. And even here, whatever amount that I have to spend, I can recover that from the contractor. Why? Because I am not I don't have an employer-employee relationship with those contract workers, right? So why am I incurring those costs? So I have that option of recovery of whatever wages I've paid from the contractor. Okay. Likewise, provision of welfare facilities now, providing first aid boxes to contract workers, canteen facilities to contract workers, everything, that responsibility rests with the contractor. Again, if the contractor fails, then the principal employer would be responsible to provide these welfare facilities. Okay. Again, with respect to social security contributions like EPF, ESI Act. So in all these statutes, it's very clearly mentioned that the principal employer can be held liable for contributions in respect of contract workers if their own employer hasn't deposited contributions. And last is maternity benefit. Remember, I told you that the definition of woman under Maternity Benefit Act is wide enough to cover even contract workers, right? So again, if maternity benefits are not being provided by the contractor, a woman contract worker can approach the principal employer and ask for these maternity benefits. Okay? So I guess we are done with the basics of employment and labor laws. I know there would be several questions around these laws. A lot of things I've skipped as well. You can actually, Mansi and other people in Center for Labor Laws, you can actually collate all the questions and send them to me. And I will try to address them as and when I get the time. And tomorrow, yes, we'll meet again, and we will discuss about labor codes. I'll try to address the concerns that some of you may have that, it's just a drastic change. We'll have to study both labor codes and this. So I'll try to address those things. And my personal favorite session is going to be, life of an employment lawyer. I'll try to basically instill some kind of an interest in you guys in employment laws, because trust me, it may look boring, but it's not, and it's actually quite interesting. And I also happen to be an employment lawyer by chance, but here I am, spending 3 years in the field of employment law and loving every single day of it. So I'll address all those things tomorrow, and in the course of today, you can share the questions with me.
Definitely, ma'am, I'll do that. Thank you so much for the insightful session. I'm sure our participants benefited from this a lot, and they have a lot of takeaways as well. Thank you for your time, Diksha ma'am.
Thank you. Thank you so much.
Yes.
See you guys tomorrow.
Yes. For the participants, Diksha ma'am will be joining us tomorrow as well. And now we'll be taking a 15 minutes break. I would suggest that you do not leave the meeting and just mute yourselves, and we'll let you know when the session starts again. And Sachin sir will be joining us for the next session. Thank you so much.
Thank you. Bye-bye.
Bye. Bye, ma'am.